Hi, I'm Darcel Lobo and I own Dow Law Firm in Normandy Park, and today's topic we're going to talk about leaving an estate to a minor. Now, what does that even mean? This is when either in your will you've named your minor, whether it's a child, grandchild, someone who's under the age of 18 to receive something from your estate out of your will. Or maybe you're naming a minor as a beneficiary of a life insurance policy or some other kind of financial account. We're going to go over why you should not do that. Okay? Do not leave anything to a minor outright. So let's get into why. So, and again, I'm only licensed in Washington State, so this is information for you in regards to Washington State. And so if you're outside of Washington State, you'll want to talk to an attorney in your state to confirm what the options are for you in that state. But for Washington State, that's what we're going to discuss. Here we go. So under state law, a minor is not competent to inherit anything. Okay, so even if you named your child as a beneficiary of a life insurance policy, they're not going to just receive that money outright if they're not over the age of 18. Okay, so in that scenario, depending on how much the funds are, there could be a whole guardianship opened for that minor to handle those funds if you've named a minor and you've passed away. Okay, so the court's going to get involved. It's a very time-intensive process. It's a very expensive process, and it really limits how those funds can be used or invested on behalf of the minor. So with some small steps and some proper planning of your estate plan in your will or in your trust, we can avoid all that from happening. Okay, so if you want to provide for a minor, we can do so, but how do we do so? We don't do so by naming them outright as a beneficiary or naming them in the will directly. There's the two main options that I use with my estate plan. One is a Uniform Transfer to Minors Act that we have here in Washington State. This allows you to designate someone as a custodian to manage assets on behalf of that minor until they reach the age of majority. So at least 18. I believe it goes up to age 24 or 25. My memory is not serving me correctly, but it's between 24 and 25. Those funds can be distributed to the minors. So you can say, pursuant to the Uniform Transfer to Minors Act, I want, this beneficiary to receive $50,000, but not to receive it until they're age 21. I'm appointing John Smith as a custodian of that account. That's not verbatim how it will read in the will or trust, but that's essentially what it says. You're naming someone as custodian of those funds to be in charge of those funds for the minor until the minor reaches a certain age. Again, at least 18, I think up to 24 or 25. My memory, I'm kind of blanking right now, but it's between those two ages. So that's option one. That's the simplest option. The second option is not that it's not simple, but it's a little bit more wordy in your will or your trust than using the Uniform Transfer to Minors Act. So that's creating a trust for minors. This allows you to designate someone to be the trustee of the trust for a minor and have more, I would say, strings attached to that inheritance for a minor. Okay, so you're naming someone in charge. You're specifying what age you want the minor to receive those funds, but it doesn't have to be one lump sum at one certain age. And it could be longer than the age 24, 25 that the Uniform Transfer to Minors Act allows. So you can do age 30, you could do age 40. At some point, that trust for the minor has to end. It can't continue indefinitely. But for a lot of my clients, and it's going to depend on how much the minor is set to receive, but for a lot of my clients, they really like a 25, 30, 35 split, where it's broken into thirds, and the minor gets 1/3 at the age of 25, the second third at the age of 30, and the last third at the age of 35. I find that allows a minor to not blow through their inheritance, hopefully. It gives them multiple kind of bites at the apple to, use the funds more wisely. And at those ages, 25, 30, 35, maybe they're getting married, maybe they're starting a family, and so you're providing for them in their future and really protecting the funds to hopefully, not have them be just depleted immediately if you were to leave one large lump sum. Now, again, it's going to depend on how much you're leaving the minor, so that's going to affect the distribution schedule as well. For some smaller distributions, it might not make sense to break it up into thirds, but for larger distributions, it makes sense for a lot of my clients. And then also, aside from the 25, 30, and 35 distribution, in between or even before those ages, the trustee union in that trust can provide for the minor's, health and education and well-being throughout. So if funds need to be paid to care for the minor, that can be used, but the minor is not receiving any outright lump sum distributions until they've reached the ages that you specified in that trust for minors. So again, the trust for minors kind of gives you more control, lets you place some more strings that to attach to that distribution versus the Uniform Transfer to Minors Act. So those are the two options that I primarily use with my clients when we're providing for minors. Again, it could be children, it could be grandchildren, anyone who's under the age of 18 that we want to provide for. So again, I recommend, even though an 18-year-old is competent under state law to inherit, usually I don't encourage my clients to leave a large lump sum to someone at the age of 18. Now, ultimately, it's the client's choice. I'm here to give you my advice and to guide you and let you know kind of what your legal options are. But if you tell me, Darcel, I want my child to receive the lump sum at age 18, I'll discuss pros and cons with you, but it's your will or it's your trust. So we're going to do what you want to do as long as it's valid and legal. I want to make sure that you are making a well-informed decision when it comes to your estate plan. Okay? So I hope this helps. If you need to provide for a minor, if you currently have a minor listed as a beneficiary of an account and you want to get a proper estate plan in place, you don't want that minor to have their funds go through a guardianship, give our office a text, give us a call, give us an email. We're here and happy to help you. Again, we're limited to practice in Washington State. So if you're outside of Washington, I would not be able to assist, unfortunately. But if you're in Washington, we're here and happy to help. The number is 206-408-8158. Thank you.